to inbox. I'll take a minute. And on the 12th of November, that is coming next week, spring bouncing, bouncing back from the rejection. So it's a very interesting story by Ambi Parmeshwaran. You know, Ambi is a great brand ambassador, brand leader, and along with him, Nandini Dias is CEO of Lodestar, and also Vinay Kamath, our own from the Indo-West line. Then on the 17th number, again, the Swamiji joining us from USA, Jagat Guru Kripalaji Yoga Center, USA, Swami Muktananda is going to be talk to us the science of mind management. He is again the brilliant speaker, brilliant author. He's from IIT Madras and I am Ahmedabad, so it's worth listening to him. Please do join. It's happening on 17th of November. Then on the 21st of November, we have again interesting program with the Ponds veterans, entrepreneurial management versus professional management, and promoter-led companies versus professionally led companies. So we got again two outstanding speakers, Anand Kripalu, Managing Director Digeo, and also Raghavendra Ravi, consultant, coach, mentor. Then 24th, we have intellectual property right. On 25th, again, not to be missed event. This is being organized by the MMA Women Business Council. Marketing through social media and how to startup can benefit out of it actually. And we got two outstanding speaker again, Ms. Anusha Shetty, Chairman and CEO of Grey Group, and Kritika Balasubramaniam, founder, CEO of Stopper Shop. This is what's happening. I think now the people are almost logged in. So let me have the proud privilege to welcome each one of you who have joined this event live from all our social media portals, our live MMA webcast, live on YouTube, live on Facebook, live on Twitter, and also all the people who are listening to our audio live from different part of the country, our MMA, Voice of MMA. Now, this is a subject which I really don't have to talk. You all, the people who are logged in, all expert in this field, labor law reforms and industrial relations. This is a subject which many people have been requesting to have a discussion since the time the government has enacted the new rules and regulations. And we thought, let's discuss. You know, over the 100 years, the labor reforms have taken place, and all the time when the reforms happen, it is people always thought it's pro-labor because labor is one or underprivileged. They're always deprived, and the capital versus labor is always that labor wins over earlier. Since the time the 91 reforms started, the things started moving on, and this is one area which is being touched upon after the reforms implemented number of initiatives. Now, post-pandemic, and number of issues are happening where we are really looking for capital, and also the technology is involved in the terms of artificial intelligence, machine learning in terms of labor. How do you manage labor? How do you balance? And how do you also attract a large number of investment? How you make the labor is really attractive in terms of for the manufacturing, and as well as how do you bring in the labor and the management, both of in the same coin, how they are going to add a lot of value to the system. To discuss, we have four outstanding panelists here, the outstanding guests of honor with us this evening. Let me warmly welcome each one of them. We have with us this evening Dr. Ilangovan, Director General of Ministry of Labor. Then we have also with us Dr. Krishnamurthy, he's the Director of Industrial Relations Institute of India. Ms. Uma Rao, Vice President HR from Ashok Leyland, and Mr. Anand Gopalan, Barrister T.S. Gopalan Company. And we also have our special guest and members of MMA Managing Committee, and also Mr. Balraman, our past President and Managing Director of thing, and who has been responsible for our Ponds Veterans series. He is also there. Now, let me have the proud privilege of welcoming Dr. Ilangovan, and let me briefly introduce him before I request him to deliver the keynote address, which will set the tone for Dr. Ilangovan is the Director General of DGAFASLI and the Ministry of Labor and Employment, Government of India. He's a PhD from Industrial Safety from Alagappa University, Industrial Safety expert, and he's also a chairman, member of Secretary of number of companies. He's led auditor, completed his course with Occupational Safety Health Modernization, and he also done number of similar course in USA. Then he has represented India G20 at OSHA, and he's a specialist in she culture, and he's actively involved in OSH activities, and he's also he's one of the authority in industrial safety investigation, and we MMA had the privilege of interacting with him, a good friend of mine, and we do a lot of work together in the field of safety, occupational health hazard, and very warm welcome to you, Dr. Ilangovan. May I now request you to deliver the keynote address, please. Over to you, Mr. Ilangovan.
Yeah. So good evening, co-panelists, and my good friend, Group Captain Vijay Kumarji. I would like to thank the panelists, particularly Dr. Krishnamurthy, Ms. Uma Rao, and Mr. Anand Gopalan, and dear participants, ladies and gentlemen. And first of all, I'd like to thank MMA, in particular, my good friend, Group Captain B. Vijay Kumarji, for inviting me to share my thoughts in this particular discussion amongst the August gathering. And probably being labor reforms, I think you might have thought that I'll be a right person to speak something on the labor reforms, what's happening. And many of you know, because labor is a concurrent subject, both state and central government have, I think I should be audible. I have no.
Yes, quite. Stand fine, Mr. Lagon. Very good.
So, being a concurrent subject, both the state and central government have equal role to play. All of us know about it. And the laws are made in Parliament, Government of India, and sometimes laws are made in the state assembly also. And coming to enforcement, then the whole spectrum is divided between central government establishment, PSUs, then the Government of India enforces through their officers. Other than the central government and PSU establishment, the enforcement lies with the state government. Only one legislation, the Factories Act is one legislation where we are the administrators of the Factories Act. You will find that this act is made by Parliament of India and totally enforced by the state governments through their inspectorate. And DG Fastly, the Director General Factory Advice Service and Labor Institute, our organization, we are the administrators of the Factories Act. We create model rules, we create, coordinate with the state chief inspector of factories and other authorities so that we ensure uniform standards of safety and health at the workplaces. And coming to this labor law reforms, in fact, this is an important issue, labor law reforms on industrial relations, which is, I would say, quite an overdue issue. You take many legislations, what has been subsumed, around 44 legislation, which has been subsumed under four codes. The first code was the Code on Wages, which was passed by the Honorable Parliament in the year 2019 itself. Now, in the year 2020, the Occupational Safety and Health Working Conditions Code 2020. We are also having the Industrial Relations Code 2020 and the Code on Social Security 2020. These are the four codes within which all the 44 legislations have been subsumed and distributed. And by seeing the title of these codes, you will appreciate that each and every code is specialized on a particular topic. The Code on Wages specializes on all legislation pertaining to wages, Work Payment of Wages Act, Minimum Wages Act. Then we have the Industrial Relations Code, which is purely covering all the legislations on industrial relations, like ID Act and so on. Then with the Code on Social Security, which talks about all social security legislations, ESI, PF, and other workman compensation, all the social security related issues. Among the four codes, the code which we deal is the Occupational Safety and Health Working Conditions Code 2020, which is an important code which subsumes almost 30 legislations. Out of which, 5 legislations are on occupational safety and health. The primary thing is the Factories Act 1948, the Dock Workers Safety, Health and Welfare Act 1986, Mines Act 1952, Building and Other Construction Workers Act 1996, and the Plantation Labor Act, apart from other legislation, because these are the four legislations which have original jurisdiction for implementing the safety and health. And you must all be knowing, once the codes have been already passed by the Parliament, now the Government of India is in the process of making rules, then notifying it, and so on. Ultimately, the labor law reforms is a much sought one, so that the primary objective, if you look when it comes to occupational safety and health code, we look into kind of what are the transformations that has taken place in the industrial scenario, how the safety, health, and has progressed over the years. If you say the factory side, which came back in 1948, it was amended to a certain extent in 1976, and major amendment took place in 1987 after the Bhopal gas disaster. And after that, this is the major exercise by which the whole act is being relooked. Like that, the process changes, the equipment changes, technology changes, the system changes, complete management aspect changes when it comes to occupational safety and health or the labor subject. So all of us definitely will agree, that these type of codes, making it in a four code and then making much more simpler as well at the same time making it stringent to benefit the laborers working in establishments as such is a big exercise. And these reforms definitely now it has to go with central rules, then we have to go with implementation, and it has to go on and proceed in multiple stages. I'm really happy, I have great experts, one from industry side, one from the IR side, and another my good friend Mr. Anand Gopalan from TS Gopalan, particularly on labor related laws and other aspects. This panel discussion will definitely throw a lot of light on how we can go ahead with the code and what could be the methodology by which we can improve the labor law system and how the IR and reforms can go together. In fact, you can see here the wages, your own, IR, industrial relation, or social security, or the occupational safety. These are the four sides, of a, system. Without anyone, the labor will be exploited. So there had to be a complete blend, harmony, and mixing of all these four aspects for ensuring decent workplaces, ultimately decent, safe, and secure workplaces. To highlight few things on the code on occupational safety and working condition, this particular code it talks brings in a national advisory board, a board to set standards on occupational safety and health, and it is also talking about the setting of standards based on the need and necessity of the workplace. So the laws have to be vibrant and it has to be highly accommodative and transformative so that what are happening in a workplace it should be able to capture, it should be able to address, and the obsolete provisions under the statutory system should be given away. This is the basic purpose at which the present legislative framework has been given. And I hope, sorry, I could may not be able to present for the entire panel discussion as I am preoccupied on other works, but I'm sure the deliberations will give a great knowledge to you, a lot of inputs to all the delegates, and I will definitely take it from my colleague, my friend, Group Captain Vijay Kumar, what's happening in the entire panel discussion. I think with this keynote address, I once again thank my co-panelists as well as the MMA for giving an opportunity, and in particular, Group Captain Vijay Kumarji. Wish you all the best. Thank you.
Thank you, Dr. Ilangovan. Thank you. I know how busy you are in the ministry putting the rules together. And surely we'll like to have you there. I think the system will change and we'll have it over you at MMA. And along with, as you committed, we'll bring the labor minister too. So we'll have an high-profile conclave today to discuss from the government perspective what's happening and to set the context, which is very, very important for us to take it. Really appreciate you joining us in spite of your commitment. Thank you so much. If you can join us later, the panel discussion for a Q&A, that'll be great. But otherwise, I will keep you posted. I'll share the entire video with you so that you can have a look at it. You know what exactly is happening from the perspective of industry. Thank you so much, sir, once again. Now, it's indeed my proud. We're all waiting for the actual moment of panel discussion. We have three outstanding panelists, as I mentioned to you earlier. We have Dr. Krishnamurthy, Director of Industry Relations Institute of India, Mumbai, and Ms. Umarao, Vice President, HR, Ashok Leyland, and Mr. Anand Gopalan, Senior Advocate, Barrister, TS Gopalan Company. The format of the event is that I'll have the privilege of introducing each of the panelists. Thereafter, Mr. Anand Gopalan will take on, and each of the panelists will share their perspective. Then there are a number of questions. As usual, if you have any questions, please do put them in the chat box, which you're all aware of it now. We'll pick up and pass it on to the distinguished panelists. And also, if you're watching this program live from any of the social media portal, you can see the number, mobile number there flashed on the screen. You can send it by WhatsApp or you can send it by email. So my team is collating all the questions, which we will collect them and put it across to panelists to address your concern. Let me have the privilege of now introducing Dr. Krishnamurthy. Dr. Krishnamurthy, can you please change the slide one? Yes. Dr. Krishnamurthy. Dr. Krishnamurthy is the Industry Relations Institute of India Director. And Dr. Krishnamurthy is son of S.R. Mohandas. Why we put this is Mr. Dr. Mohandas is a dion in the field of industry relations. He's the one who is always been consulted by any of the people, both ministry outside, in terms of industry relations. So the gene is passed on. So we have Dr. Krishnamurthy talking to us. He's from Bajaj Institute, and after doing a PhD in LLB, very senior advocate, specialist in the field of labor laws, and conducted several conferences, workshops, and seminars. And he's also the internal campaign committee of several Indian multinationals. So you are going to have an exciting input from Dr. Krishnamurthy. Very warm welcome to you, Dr. Krishnamurthy. It's a pleasure to have you with us. Let me have the privilege of introducing Ms. Uma Rao. Uma Rao is not new to Madras Management Association. You have seen her on many occasions in our MMA activities. She is an HR professional and experience about 2 decades, and worked leading organization of Tata Consulting Services. And I've seen her actively participating in a number of other organizations. She's very active in Madras Chamber of Commerce. She's come and spoken many occasions in MMA. She's the one who always, when we welcome her, invite her, she's always come forward to share, be it in HR services or industry relations or women issues. She's always there, and she's very, very passionate about empowering women, and she does quite a bit of work with us, and we also participate in our women conventions. So she strongly believes that women empowerment is very, very important. They constitute 50% of our population, and they should be given due place in as far as the women in a lot of activities concerned. What is this very news? What you almost read is many women working from home finding it difficult and giving up. This is the time I think we need to do a lot of things, and Uma is one who is closely associated with empowering women. Then we also have with us Dr. Anand Gopalan. Anand Gopalan is a barrister. Anand is a second generation lawyer, and he then took a paradigm shift towards labor, industrial law, and joining T.S. Gopalan Company, and completed his master from Cardiff University. He has also often briefed senior counsels on a number of issues, in particular labor issues. Anand is also a member of Madras Bar Association. He is the chairman of Export Committee of Labor, and he's addressed conferences and a number of things. And Anand, when I spoke to him, right away agreed to do this session for MMA at a very short notice, because there are a lot of requests have come to MMA. That's why we are able to bring it to you, an outstanding panel. Thanks so much, a lot of viewers who are joining this on our own Zoom, and also all other social media portals. Very welcome each one of you. Now I'll hand over the session to Mr. Anand Gopal to take it forward. Over to Mr. Anand.
Thank you, Captain. As Captain put it, it will be that each one of us would get to just share something about the codes for the first 5 minutes, our views, and then there would be a slight discussion amongst ourselves, and then throw it open to questions from each one of the participants. The point that I wanted to bring out in these codes is twofold. I'm going to restrict only to 2 things that would need to be brought in. The codes were meant to bring uniformity. The uniformity has been brought in one aspect, certainly, that's definition of wages. So if you look at the definition of wages across all the 4 codes, it's the same. And why do I stress this? Because this definition is one that's going to have a financial impact on all businesses. So every business person who's looking at what is the impact financially because of the code would need to take into consideration this definition of wages. Nothing major, but companies which had the basic wages or DNS allowance at a slightly lower percentage of the gross wages, for them it's going to pinch. So depending on how low you're pitched in your basic or DA, the lower you pitch it, the higher the pinch, or it's going to be more severe on you. So what the definition now reads is that basic wages and DNS allowance should be reckoned to the exclusion of all allowances. But if your basic and DA is less than 50%, then 50% would be reckoned. So for instance, if somebody's salary is, gross salary is 20,000, but basic and DA is only 6,000 of the total, then the salary will be deemed, the wages would be deemed at 10,000. So it's not 20,000, 10,000. So what is the impact that I'm talking of? For instance, you would have been paying gratuity only on the 6,000. Now, because of this definition of wages, this gratuity becomes the salary for the purpose of gratuity calculation becomes 10,000. So especially when you go higher up in the level for your top executives, of course, there is going to be a cap on the ceiling on gratuity, for instance, but this is the impact that is going to be there. Similarly, if you're taking only basic and DA for overtime wages, and if your basic was only 6,000, so when you pay overtime now, your wages that you would need to reckon is 10,000, not basic and DA alone, because some industries reckon only basic DA. So in this aspect, everywhere, so ESI, PF, in all aspects, there are going to be repercussions on this definition of wages. That is, I think, the key takeaway that I would like to first point out as to when it comes to these codes. And one advantage that was there is, even under the minimum wages, mostly when engaging contract laborers, what was happening is the minimum wages was split. So if the government says the basic, the minimum wages for an industry consists of 6,000 rupees of basic and 6,000 rupees of DA, totaling to 12,000. The definition of wages under the Minimum Wages Act included house rent allowance. Similarly, it got excluded under the Provident Fund. So people were structuring this minimum wages. So 4,000 basic, 4,000 DA, 4,000 HRA. Still, they will be complained under the Minimum Wages Act. They will need to pay PF only for 8,000. This was one aspect which was available. But now, after this new definition, HRA is excluded. So is all other allowances. So there's no more splitting of minimum wages. If the government says the minimum wages is 12,000, you have to pay 12,000 as basic or basic and DA. So there's no more splitting. So in this manner, this definition of wages is going to be having a repercussion. But at the same time, there are a lot of places where you may save. For instance, the same definition would reduce your retrenchment or closure compensation by 50%. So for retrenchment compensation, you would be taking, as the example I earlier gave of 20,000 rupees as the gross wages, you will take 20,000 and on that you will calculate the retrenchment compensation or closure compensation. But now given this definition, 10,000 alone would need to be reckoned, even for closure or retrenchment compensation. This along with the 300 increase, the chapter 5B, which used to be at 100 workmen, you need to take permission. Now 300 workmen and above alone, you need to take permission. So this becomes a double bonanza for employees here. One side, the smaller factories up to 300, they don't need to take permission. At the same time, the retrenchment and closure compensation gets reduced. So in this manner, this definition of wages has an impact in every code. So be it the code on wages, it will have impact on minimum wages, bonus, etc. If you take the occupational safety, it's going to have an impact on the overtime. If you take the code on social security, it's going to have impact on everything, PF, ESI. See, for instance, ESI is again, if I take it, it was only 21,000 is the ceiling limit. Now, because allowances gets excluded, which was included for purposes of ESI. So even somebody who's earning 35,000 rupees, he will come within the ambit of ESI. But the wages that you will be taking is only around 17,500 for contribution purposes. So though you may save on the contribution amounts, more number of people will get covered under the ESI. Of course, we need to see what is the ceiling the government is going to fix in the new ESI and PF codes if they come, whatever is the changes that they plan to do. So that's one aspect. The second aspect is all these codes don't have an universal application. What do I mean by universal application? For instance, much has been spoken about the code on social security, which brings about plans at least or provides for gig workers, platform workers. So all your Swiggies and Ubers and Ola and all these workers are to be brought in. There is going to be a social security scheme for this group of workmen or employees rather. I won't use the word workmen, employees. But these employees don't get covered under your IR code, Industrial Relations Code. So it's not that they can raise a dispute before the labor code or they come within the definition of the occupational safety health. So this set of employees get covered only on the social security code. So it's not that all employees get covered in all the codes. It's only in some codes alone they may get. So for instance, again, factories like OSH, if you go, it's only the factory portion of OSH alone they get covered if they're working in a factory. Similar to employers also. For instance, charitable organizations are taken out, philanthropic and charitable organizations. The industrial relations code will not apply. So if you're running a hospital on charity, if you're running a college, which is again a charitable institution, then the provisions of the industrial relations code doesn't apply. But that doesn't mean that the code on social security will not apply. So ESIPF may still continue. There is a possibility, but IR code is certainly out. So they won't come within the definition of industry when it comes to philanthropic or charitable organization. So such an exclusion is provided for. Similarly, when you look at code on wages, people who are drawing 24,000 and above were excluded. The code on wages as of now doesn't provide for any kind of exclusion on ceiling on that. I don't know, somewhere are they going to bring it in the rules? We need to wait and see. I doubt it though, because if it's not there in the code, to bring it in the rules may not be permissible. So even if somebody is getting 75,000 rupees, he is also considered as an employee under the code. And going into the same definition of employer-employee in this codes, you also need to remember all the codes have two definitions, both employee and worker. The employee is more broader, brings within its ambit any person who's employed, whereas the worker is more restricted. It doesn't bring in people who are managerial, supervisory cadre. They are not brought in within the definition of workman. These words are being interchanged in all the codes. So whenever you look into any provision of the code, you would need to look into whether the term used is employee or worker. And depending on that, you need to interpret the provisions. So these are two key things that I wanted to point out. One is the wages and the other is the employer-employee and applicability of the codes to organizations and as well as to employees. With that, I would request Dr. R. Krishnamurthy to share his views on these codes.
Thank you very much, Anand, and I thank MMA for this opportunity to be here with you and share my thoughts on this subject, which is very vast. Modi 1.0 brought in quite a lot of changes, but he didn't have the power in the Rajya Sabha. So he could not get any of the important acts passed, and therefore he had to wait out for Modi 2.0. And even though he did not have a full majority, he has been able to get through some of the major amendments and Article 370 and many things, including the labor codes passed. What is the perspective on that? First and foremost, many changes have come in, in a manner where many of the BJP governments initiated that change. The issue relating to Chapter 5B, which is still a millstone, let's be very blunt. Either you liberalize or you don't liberalize. You can't have a halfway house. Most of the businesses have more than 300 workmen. Almost 10% of the big companies have that. 80% of the companies have 300 or less than 300. So you have liberalized this sector, saying that no layoff, retrenchment, closure permission, you can go ahead and retrench and close. That is going to be a big shock for many of the workers and unions, which are ensconced and comfortable and had a lot of restrictive practices. So Code of Industrial Relation busts this. Similarly, less than 300, no standing orders, which means you have what you decide is final. So I can have a probation period of 6 months, 1 year, 2 years, 3 years. I can terminate people without going through this normal process, which we have elaborate inquiries and all that. So your own service rules can define your environment, and it is ease of doing business for employers enhanced substantially, particularly if they are small units. But there are other issues which we need to really look at, and I think Anand has covered this point relating to the code on wages. First and foremost, I would like to say that the code is a very sloppy job done. You have included, payments. Now, there is we always have had this history of basic wages, DNS allowance, and allowances. And over a period of time, workers and managements both agreed that they don't want everything to go into the provident fund account. they consciously kept out a portion of the wages and it became substantial. 70 to 80% it became allowances, and 10 to 20% became basic wages and DA. Now, this is a conscious decision. Now, very often, even judgments, settlements and judgments have provided for this. And now you're saying that this will not be wages. I'm sure this is open to legal challenge. The manner in which the definition has been done, I think, as far as uniformity is concerned, it's a very big thing, because you had one definition of wage in PF Act, one definition of wage in ES Act, one definition of wage in Industrial Disputes Act, one definition Payment of Wages Act. So all these things, to an extent, it has improved the ease of doing business. More importantly, the issue relating to bonus, the manner in which many amendments have come in shows that the people who are involved in this do not have much of an understanding of the realities. For example, in bonus, they have fixed the limit 7,000 or minimum wage, whichever is more. Now, this is being a variability in terms of the bonus paid to employees in different locations for the same salary and for the same profit in different branches of the company, same company. You are required to pay different bonuses. How is this fair? And I think that's something which somebody who was drafted it did not have an understanding of the reality. So like this, there are many issues. So when you really look at wages, the definition of wages also shows that the predominant emphasis has been not to allow basic wages to remain low. So they have padded it up wherever the allowances are more than 50% or of the total. So this is something which is there. But the Code on Industrial Relations have brought in quite a lot of pain points. When you talk about ease of doing business, the pain of doing business in industry that has become enhanced. It has not become easy. So when you say ease of doing business, I think employers wanted that the world of 3D. You're having manufacturing now, which is coming in. 3D is going to bring in very significant changes. 4R, we say digital technology is bringing big transformation. 5G, communication, driverless cars. So you're going to have robotics and other things that are going to happen. IT, OT, machines talking to each other, machines, intelligent machines, artificial intelligence and robotics. Now, this is the type of changes that are going to take place. And for every change, as long as I ensure that the wages of the workmen are not adversely affected and they are not terminated, that's all that as an employer I'm obliged to do, and I must be given the freedom to bring about the change. But no, notice of change is there. And this government has usurped huge amount of powers. The notice of change can be changed by the government. It can be disallowed. It can be modified. They can give permission. Award can be changed. I'm yet to come across a situation where an executive will sit in judgment over a judgment of a court to modify the award. Is it possible? But you will find this in this so very high degree of executive, freedom. And when you say executive freedom, it is also a situation where you have the possibility of misuse. And I think one of the issues that is particularly concerning the employers is the very heavy fines and the imprisonment terms added to boot. This is something which is very shocking. You treat an employer as a crook. And this recent incident of Arnab Goswami, some violation of the law, and he's in jail. Now, this type of discretion given to the executive is something which is disastrous. Most of the people will use it legitimately, but there will be some mavericks, and this will actually create problems for the employer. So this is something which is very difficult. And I think when you look at the pain of doing business, Chapter 5B has been eased to 300. That is, of course, what Anand mentioned. But issues which we had, like many of the employers had problems relating to the strikes and lockouts. Workers taking recourse to violence, coming inside the premises, occupying the premises, preventing movement of goods and material. That's a very major issue. Protected workmen. Many of these issues have not been addressed. And I think these are the pain points which many industry and people are facing. Then, the issue of unionism. Now, where there were no unions, one union can become the sole bargaining agent. You will have unionism coming in left, right, and center. You have provided a facility that if there is one union, it will be the sole bargaining. And you're going to see quite a lot of problems. I envisage quite a lot of issues here. The negotiating, the sole bargaining union, the negotiating council. Then the mechanism you have provided of two persons who will be sitting on the tribunal, one who is an administrative member. This, I do expect a judicial challenge to this, particularly where the right to appoint judges is that of the judiciary. You are now making people judges left, right, and center who has absolutely no there's no need for even legal qualification. He can be an ordinary person. Is this valid? So there are some issues here which I have. And then, when we look at other codes, like for example, the code on occupational safety, health and welfare, I think the central piece there is the Contract Labor Act. And I think what Modi wanted to emphasize was the ease of doing business. And I think to a very great extent, contract labor has been, the pain from contract labor has been eased. And I call this the Indian disappearing rope trick. Okay, when you go abroad and ask people what is India famous for, this is a land of magic, land of elephant and land of magic. And somebody will have a rope, that rope will float in the air and he will climb up the rope and he will disappear. This is the Indian disappearing rope trick. Okay, and now we have got the Indian disappearing contract labor trick, where you give one letter of appointment, give him increments, cover him under social security. As it is, contract labor was covered under social security. Even if the contractor didn't have a code, I had to put him in my code and contribute. So social security, all that I have to do is just give him a letter of appointment. And lo and behold, he is not contract labor. What is he? That part, we don't have to understand and bother about. He's not contract labor. That's what it is. And then you get into what is called core area and core activity and non-core activity. And you say in one mouth that engagement of contract labor in the core activity is not required. It will not be permitted. And then you say that no, if it is of intermittent activity, that is permitted. If others are using contract labor in that activity, that is permitted. If it is less than 8 hours, that is permitted. No, I mean, when you frame a law, be very clear. But I think here the intention is to facilitate all employment in the engagement of contract labor, and that's something which is done to increase the ease of business. But if you really see the pain of doing business, and I think this is one of the issues that is going to come, you have certain very unreasonable and illogical expectations. You have to settle the dues of people in 48 hours. If in 6 months you don't settle the dues, you have to hand it over to the government of India. And if you don't do this, 10 times the fine you can have, that is one choice, or go to prison, or you can compound the fine and pay a small amount, composition of the fine, pay half of that, and then first offense is okay, second offense, definite prison term thrown in. So I think, if you really look at it, it has been done in a very shoddy manner. I think somebody needs to have done a thoughtful process of looking at it and completely removing this element of criminal, prosecution. It is there and done for somebody who has committed a crime. It is not done for technical offenses. Increase the fine. You have done a very good job by increasing the fine by almost 10 times to 20 times. Increase it by 100 times, no problem. Let the employer realize that he violates some business, he has to pay a very economic fine. But sending him to jail, it's absolutely absurd. So these are some of the preliminary points. I think with that, let me conclude and leave it open for Uma and then more in question and answers to answer some of those issues. Thank you very much. Once again, thanks a lot, MMA, for giving me this opportunity.
I think Uma, you take it over. Anand is coming.
We'll request Ms. Uma Rao to share her views, and then we'll take questions. Uma, over to you.
Thank you. If there's anything left after both of you have spoken, I'll try and look at that, because I think that's a very exhaustive rundown, Dr. Krishnamurthy, from your end, as well as Anand. But a few things from my side. I think definitely it's a good thing that so many acts have been brought down to 4 codes, which is very heartening, because otherwise, as an employer, practically speaking, the number of licenses you have to take, number of returns you have to file, number of, disputes you have to entertain in different areas and definitions of wages, etc. I think it was a big pain. It is a big pain. And hopefully this will get eased with the situation that we are looking at. So this is a hope, because we have to see how it works out. The other one is, the whole licensing business also entailed a lot of other things in terms of, reaching out to several people to help out and then payouts and things like that. So that also is something which one is hoping that will go away with this. Many clauses have been talked about. One of the couple of things that I wanted to touch apart from what you said. One is about the, the women that you talked about. So I think there is Equal Remuneration Act which comes into a play, which is a very good news for women, and night shift working and things like that. So that is something which is very welcome. Hopefully it will open the door for more women. And the other piece is about legitimizing the gig workers. From statistics, it tells that many of the gig workers are actually women because they can do it from any place, any place, any time kind of a work. So I think this is also something which is very encouraging. What is also very good is I think the social security measures for migrant labor, passage home once in a year, registration for them, 1 to 2% of the annual turnover to be, given by the companies for the social security of migrant labor. I think for our kind of industries, they are very important for us, and this is something good. Right? I think the single industrial tribunal, instead of hundreds of district courts to go to, I think this is also something which is good. How it gets into play is something to be seen, but that's good. What I also liked about these is the grievance committee. The composition of grievance committee has gone up from 6 to 10. The idea is that grievances arising out of these kind of arrangements will be handled by a wider section and diverse section of people who form the committee, and therefore the apprehension that it will be a higher fire rule, I think, will be kind of taken care of to some extent. I think the other important thing is the various reforms that have come in the occupational health code, and also the merger of the definition of wages, which is good. But as all of you have said, I think the clarity is not very good. There's some things which are a big question mark with regard to what is happening. You actually are allowing more women to get into the workforce, which is absolutely great. But I don't think the conditions have been laid down for the safety and security, even as you open it up to all the industries. Secondly, we don't know what is going to be the penalty for violation as yet. If it is going to lead to more violation and no penalty at all, then I think this move is going to be counterproductive in many ways, as I look at it. Then the rules are yet to be formed, and they are being formed. And one hopes sincerely that there's not too much of conflict between the, the central and the state rules, because then it becomes counterproductive. I am also wondering what happens when people move from one part of the country to the other, and they happen to be the gig workers. How will the social security work for them and things like that? In general, the violations, and Dr. Krishnamurthy touched upon that, while it should not be penal and jail, but I think there has to be something which should deter people from doing something out of the whims and fancies, rather than doing in the right manner. One clause says that you cannot allow to hire people who are less than 18 years, but you're also allowing apprentices at 16 years. So how does that work? And who's going to regulate what these apprentices are going to do? Because I understand very well that in some places they actually do the work on the line in the name of being an apprentice. So there's a conflict that is seen very clearly. Also, the organization safety health code talks about 250 workmen to have this kind of a framework for the organization safety and health. Now, the issue is there are almost 90% of the companies, as I understand from the data, will not get covered in this. So how are we going to make sure that safety is going to be one of the prime concerns for all of us and every organization that operates? Because again, from the data that I have seen, 40,000 deaths happen in a year on account of lapses in safety and safety processes. And this is a very serious matter. And especially if it is not even going to come in the visibility of the people who matter. So I think this is something which is very serious and one should look at it. And also there's a question mark at the end that is it actually going to increase employment or is it going to increase entrepreneurship? And this is a good dilemma to have because both ways I think people are going to benefit at the end. In some ways I feel the companies will have to shell out more because as Anand mentioned at the start, there are many companies who have been extremely flexible with the way they have done their pay structures. And I think it is going to be difficult for them. But when I talk about an organization like ours and many others like ours, I think I don't see too much of a difference from what is happening because we have believed in labor relations and good labor relations for a long time. We have gone beyond what many industries give to ensure that, we truly treat them as partners in our business, and we don't really shortchange and try to look at this minimum wages kind of a philosophy. We've always gone above and beyond, and that's a testimony in the regions where we operate. So I think for us, it's a welcome move that things should become better for the labor, because they are playing a very important role in the success of an organization otherwise. And also our realization is that, if you really shortchange this important set of people from the organization, the key stakeholders, I don't think you will actually make giant strides in whatever you're trying to achieve. With regard to the FTEs that often people talk about, I think one thing that comes out is it going to lead to hire and fire? The way I look at it, especially with regard to our kind of organization, I think these FTEs are going to be niche, people with niche skills, have some special skills that we don't have. Otherwise, why would I want to give away my permanent workmen and hire all these short-term people who will take a lot of time to understand the environment, to work within that, and to maintain the industrial peace that we have at this moment? I don't think it's a very great idea for us to barter everybody else with the FTEs. So certainly FTEs will have their value, and they will be useful in certain areas and certain technologies, because as Dr. Krishnamurthy talked about this, Industry 4.0 is going to come. There'll be many things that we may not have right now with us, and we will need some specialists to come and actually help us to put some of these things. So maybe, those will be areas where we're going to look at FTEs, but I don't think there's any value in, exchanging your permanent workmen to get some people who are going to come and work for a short term, because culture is very important at our place. One is already debating as to what culture is going to be when there's going to be virtual workforce, but in the plants, it is not virtual. It is real. People are there with each other, and they have to be, running into each other and running the operations in a particular way. So I think these are very important points for us, and I don't think we'll run amok and sort of just pick up FTEs just because it's convenient to hire and fire. And we don't believe in that kind of a philosophy. So I think there's much to feel good about. There's a lot of clarity that is required. Certainly, if it adds to ease of business, I think it's most welcome. The violations have to be taken care of. If you're moving into such a free environment, which is great, I think you will have to put checks and balances in place, and also ensure that the conflict between the center and state rules really don't go too much. And people are going to move within India. And when they move within India, I'm not very sure at this moment how some of these social security measures are going to work. So this is a quick rundown from my end about what I think is going to unfold in front of us with regard to these codes.
Thank you, Uma. Thank you, Dr. Krishnamurthy. I just thought I should also pick your brains, both of you, on your views of increasing this ceiling limit of workmen of 5E to 100 to 300. Do you think that's going to have a major impact?
Can I take that?
Sure.
Yeah, I think I already talked about this in a way, saying that organizations which are already practicing the right things here, for them, it's not going to make a lot of difference. But for the smaller organizations, yes, it is going to make a difference because it will make it easy. Today, it's very, very tough to run any kind of process of retrenchment, and the 200 rules are so difficult that it becomes unviable for people to operate. If we want more people to come forward and set up industries and set up small scale industries, etc., we need to be a little reasonable when it comes to this. So that's why I said if we have a good check and balance, I don't think this is a bad thing. It's in fact a good thing.
I just want to add to this, if you see the provisions of the Industrial Disputes Act in Rajasthan, the Rajasthan government got this change of 100 to 300 2 years ago. And how many companies have actually used this for closure? You will find hardly 3 or 4 companies which are actually closed using this provision. And in fact, if you really read the original chapter 5B, the intent was that, you give permission within 60 days or within 90 days, it is deemed to be given. Now, this proactive measure was actually perverted and permission not given. And it has become a situation where even where companies like Pfizer have paid 50 lakhs for employee, Out of 200, only 120 accepted it, and remaining 80 said that no, we will not go. So cost of severance has become very high because of this type of situations. And that creates the problem. So have a law which is transparent. Have a law which has to do something with the discretion being exercised by the executive being very minimal. And then employers will be, nobody starts a business to close it. Only because the business is not doing well, they close it. And unions need to understand this and become flexible. And unions don't want anything that will change their existing status quo and control over the workers and the business. This is a big problem. Whichever the ideology, they don't even, that PMS union doesn't agree to this provision relating to closure.
Thank you. All three of us, I think, just heard 4 trade union leaders between 4 and 6 p.m. And before we joined in, all three of us heard what the unions had to share as well. What do you think is the take of the unions on these? I mean, I know it's been negative. They called for an all India strike, and they're up against everything. In fact, the recognition of union becomes compulsory with this IR code, which was only there in Maharashtra and I think Kerala. But other than that, it wasn't mandatory in other places. But despite the unions per se getting, I would say, more power through the IR code, still all the unions seems to be against all these codes. Not there are changes which are, I would say, pro-employer and pro-employee, but it looks like they're more, there's a negative attitude towards these changes. I would like to hear from both of you your views on that. Is it just that we have to oppose and so they're opposing, or do you think there's anything reasonable in their opposition?
Two things I would like to say. One is in terms of the leaders and leadership. I think today you attended that program. How many young leaders did you see? They're all oldies and veterans. So when you really look at unionism as it is today, and in the new industries like IT and ITES, there are no such unions, worth it, because the type of leadership that you have in the unions itself is also very old. So if you really look at the Trade Union Act, the getting good leaders, it takes time. To build leadership also takes time. So you cannot have leaders, who are there in the job for 2 years and thrown out just like that. So we always used to say that, when unions were there, we used to tell, amend your, code, your, constitution to provide for a leadership of at least 3 years minimum, or at least, 3 years, because, settlement times take place, 3 years is the period of time of settlement. So every settlement, you can have a leadership which comes in, but allow that leadership to stay because they have to learn. You can't keep changing the leaders every year. And here, every 2 years, you will find that the leadership gets changed. How are you going to get stability and quality in the unions if you're going to change the leadership every 2 years? Then second thing is, in terms of the interference on the right of the union, you see, I was just going through the code. The constitution of the union says that you have to file the returns by end of the year. Okay, and the years, generally accounting year and financial year are two different things. So what are you talking about? Are you talking about the financial year or you're talking about the accounting year? And then accounting audit takes time. And here, there's absolutely no thought given to the process, how this will be done. And if you see the actual process, unions will object. Any change which will be there adverse to them, they will object. The bar on strike, they can't go on strike. Then 8 days wages can be cut for go slow and other things. That they are, absenteeism and all that has been retained. Many provisions are there which unions will not like. And any check and balances of union, they will protest. They will go on strike also. There's a very peculiar situation. If there's an illegal strike, what will the government do? How will they process the matter? Then if it is a matter related to dispute of unions, how will they handle it? What is the machinery? And everything you will see, it is going back to the assistant commissioner of labor or deputy commissioner of labor. They have to do this job. And what is the machinery that is there with them for doing this job? Absolutely nil. Even for existing jobs, they don't have people. And you expect now all these problems will be dumped on the executive and you please resolve this. So if there's an inter-union rivalry situation of membership, how will they verify that? Is there, your rules prescribing that secret ballot will be held? And I think, if you go into the nuts and bolts, they have not done their homework. And this is where the problem comes. Definition of wages, nuts and bolts, not good. Definition of bonus, again, minimum bonus, what is to be paid? Not clear. This council that you're talking about, negotiating council, how one person will be deciding that, and how are you going to decide in the company when there are many unions? Okay, now in companies like, for example, Cochin Refinery, I remember the old days, there are 14 different unions. And each union can bring the whole refinery to a standstill. And you have to talk to all the 14 unions. One union was even an Naxalite union. You have to go to that manager used to say, I have to go to the jungles to negotiate with the leader. So how do you handle this diversity of situation? And the code, the code has absolutely no answers for that. And HR will be required to come up with those answers and solutions, how to handle those situations.
Uma, your thoughts on that?
Yeah, I think it's been a very comprehensive rundown. I certainly feel that certain loopholes were always made use of by the union, which will become more difficult now with the code that is coming up and the whole piece on the formation of union, etc. I think with the FTE concept, they're also worried about their membership, whether it's going to come down, because anyway, the membership of unions is dwindling, as we know, and it's going to dwindle further. That could be a major apprehension in their mind. And so I think some of these things are deterring them. And also, the collective bargaining piece, which has been so sacred for the unions, with this kind of union recognition and formation process, etc., will be a serious threat for them in terms of how they can manage to get it. So, and also, I read that the dispute has to be closed within 3 years. You cannot drag it forever. So some of these tactics that people have used to keep on dragging some of the issues may not happen in this manner as we go forward. And so this is definitely going to deter some of these things. And beyond that, I feel that it's a matter of political affiliations also many times. So that also plays a very major role in whether you want to accept it or don't want to accept it. If you really sit down across the table and question as to what is it that they don't accept, even in the seminar today, I didn't get too many points very concrete about what was not acceptable. So yeah, I mean, this is interesting because we really need to get down to the brass tacks.
Dr. Krishnamurthy, I'd like to ask you one question on the IR code. Under the ID Act, if a union had to raise a dispute, it had to go to the conciliation missionary, then the conciliation officer gives a failure report, and then it goes to the government. And the government, if it deems fit, refers a dispute. There was a kind of a check valve system that was there so that the floodgates were not open.
Very true.
But now with the removal of this reference system under the ID Act, so a union can just go to conciliation, and on the 46th day after the conciliation, it could raise a dispute. I mean, along with the recognition, one part of it, and then you have this, there's no, you have the negotiating council. It is not just that the negotiating council has to raise a dispute. It could be the union still which could raise a dispute. Where do you see this for the industry? What would be the impact on this?
See, two things which I do see as a major problem. One is, this Grievance Resolution Committee, which is there, GRC. I have done a study of the GRC's working. Not one GRC was working and has successfully raised and resolved any dispute. Because grievances are typically handled by the union leaders directly with the concerned authority and resolved, at once. It is not kept pending. They don't want the committee to take the credit for what they do. So, it has been an anathema. It's never worked. Okay, and in fact, that was one of the problems in the Grievance Committee, that, this executive nature, Parkinson used to say, you want to avoid a problem, appoint a committee. And surely a committee will come up with different views and they will not agree to it, and we will not be able to come to a consensus on that. But a dispute going directly to the authorities, it's one of the, as you rightly say, it's a Pandora's box. I don't know what issues are going to come up and what issues are going to go. You raise a dispute with the Commission of Labor and directly go to the, tribunal. And even the tribunal is also not very clear. It's going to be the administrative side member, or it's going to be the, both of them together, or only the, person who is appointed as a judge who will hear the matter. So these are all things, which the code has actually created as a confusion. And only time will tell how they will address these issues. Not much thought has gone into it. And I totally agree with you that it is going to be a good field for lawyers. So, we are going to have very good, green field. And, every law brings that, litigation and problems.
Ms. Uma, we are talking on FT, and you did share on FT how only a niche I mean, somebody who's got a very niche skill sets are going to be the people in FTE. What do you think is going to happen on the contract labor? Is more contract labor going to be engaged? No, of course, they've said core, non-core, and they bring out that split in the engagement of contract labor. And of course, they have made it less stringent. There's no registration requirement for the principal employer. At least that's what it appears to be. We still don't know. But going by the code, it looks like there's no registration that the principal employer needs to do, but it's only a license which the contractor would need to take. And even that license is not going to be like, a factory specific. For the entire state, he would take one license and within which he will just keep adding the names. Or that kind of system is what is going to be coming about as the indications. But as an industry, what do you think the engagement? I'm not just on Lylan. I know your contract system is very minimal, but I'm just saying the entire industry, do you think that this separation of core and non-core, is it going to be helpful for the industry?
Yeah, so I think even at this moment, as you know, that contract labor is employed quite a bit in most of the industries. And the reason for doing that is, of course, we say non-perennial work and all kinds of things. It could also be some of the non-value adding work, which you don't want a full-time hire to do this. And so the employee to do this, and therefore you kind of get some of these folks to do. At times, it could also be because the level of skill is very low, and therefore, you don't want to get your full-time employees to be part of this. So I think those reasons will continue even today. I don't think anything is going to change about it. The issue of core and non-core, I think it will be deployed more by the employers, because a lot of their workforce, especially in organizations like ours, will be retiring at some point in time. And you have to have some people who can, take over from them, even in some of the core areas, because hiring of the full-time employees doesn't seem very lucrative over a period in time, considering the kind of changes you will make with technology, new processes, etc. So it will also always be a situation where you may not hire 100% there, but actually employ some of these people. And the fact that it is allowing in the core area, it is better, because then you don't have to do it on the sly and kind of make it into some kind of a contract and piecemeal contract and all piece rate contracts and things like that. So I think it's better in a way that you do this, and there should be more ownership within the organization of these people, because they are going to be part of the core activities, and therefore, the way you treat them, the kind of benefits and everything that you give to them, it will also make it better for them over a period in time. So I think I would say in a way it is good. I mean, we have to get real with these subjects. Having a full-term employees because of the laws that have been prevailing has always been a difficult one. And from some experience, we can tell you that even the quality sometimes seems better with people who are on contract when they do work over there, as compared to people who are full-time employees, because they are very assured of their job and they're very assured of everything. And so, that compelling reason for them to perform, becomes a little bit restricted. And so we introduced the variable pay for them, a small portion of the salary, but it's not as if it changes everything for you right there. So I think in a way, legitimizing is good. I always feel legitimizing things is better than actually doing it on the sly. But still, there is a good reason to have your own employees on your roles for certain things, and have these set of people for certain other activities, and they can coexist peacefully.
Let me add one more perspective, Anand, if I have the time, can I?
Sure.
Yeah. You see, when we had this contract labor problem in Maruti, Maruti had about 60% contract labor and 40% permanent labor. A couple of years ago, I visited one of the manufacturing establishments of an automobile in Ranjangaon in Pune. It was a new establishment which was shifted from Gujarat to Mumbai. And I found out that there were 3,500 contract labor working on the shop floor doing the regular job, and about 300 persons who were working as permanent workers. So the ratio of contract labor to regular workers was almost 1:10. And the contract labor was being paid more than the minimum wages. Actually the minimum wage in that area was about 8,000. These people were being paid about 10 to 12,000. So they were not very unhappy. They were quite comfortable. But the permanent workers were getting around 30,000 rupees. And they were doing similar work. Now, in this code, you have eased the, engagement of contract labor, but you have provided one very important tool, that same or similar nature of work, he will be paid the same salary. And this will be something which industry needs to understand, that if they are engaging people to do the regular work, they have to pay the regular wages. And you can't scrounge on that and say, I will pay the minimum wages to all the contract labor and continue to pay that. The contractor will pay the minimum wages and then we will work like this. I think that system is going to change. And this is going to be a very fundamental change, which industry may not have envisaged, but it is coming. And the person who will decide this dispute is not the authority, which will be the judiciary. It is an executive. And who is that? Assistant Commissioner of Labor. So, and they have also defined what is similar or same nature of work. So I do see that this will be very useful for the unions to raise as a dispute and, create cost of manufacturing will really shoot up, and this, misuse of labor, abuse of labor, I would say, will completely be checked by this change or type of change that has come. Surprisingly, I didn't find any of the union leaders mentioning any of these things. They're not gone through the code itself. I could see that, this is a generic discussion. They're not gone through the code in detail. I would really question the way in which they have put accountabilities on the union office bearers. They will all go to jail. The fines that they have provided for every offense 1,000, second offense 10,000. I mean, these are all things which no union leader will ever agree. Unions have been largely left untouched. Workers who go on illegal strike will be asked to pay 1,000 rupees in the first instance, 10,000 in the second instance. I mean, these are all things. Are they just provisions in the law? Will they be used, or it is just there? Similarly, criminal provision, prosecution. Will it really take place, or it is just there in the law as a showpiece? So these are all things which we need to really look at.
Thank you. I think given we have dealt with most provisions and we have shared our views, I think we should leave the floor open to questions. Captain, could I request you to kindly take over for the Q&A session from here?
Thank you, Anand. Thank you so much. We have over 1,050 viewers watching this program from our social media portals. I received a number of questions from YouTube, Facebook viewers, and also from webcast. I will try and accommodate as much as possible. We got another 20 minutes to go, and we'll try and take as many questions as possible. Here's a question from Gurugaon, Mr. Pandey. He says, how do you view the future of labor relations as and when the new law comes into force? You also want to add, what will happen to the power of collective bargaining? And he says the government, it would have been better that they focused on ease of doing business by better tax laws, better administration, and better way of getting in, rather than tinkering with the labor law. Your views on this, please.
I think Dr. Krishnamurthy can answer it.
You can divert the question. I'll just read the question.
I'll do that. No problem. Relationship is not defined in law. Okay. How to have good relationship, that is dependent on you. Law will never be in a position to give you that, situation. So how the industrial relations will change, in my view, industrial relations are inputs that you have to make. You have to build the relationship. Relationships don't come overnight. Law can define the broad parameters and framework. And if things go wrong, what can be done? How to fix it? That's what you have to really look at. So in my view, this law is going to increase and intensify unionism where there was no unions. Where there is unions and there are stable unions, that good relationship which was there, which companies have invested in leaders and in people, I think it will sustain. You will see that these will not be buffeted by the change that has taken place in the law. So they will continue where, companies have had good rapport with the workers and, labor. They will be in a position to, ride the storm well without any problems. But where, no unions were there. Now, for example, many companies are there where there's a basic philosophy. There are some companies, American companies, who are coming in with basically one philosophy: we don't want unions. Okay, and they have prepared to pay a higher price for workers not to get into unions. So if the salary is 10,000, they'll say, we'll give you 15,000, but we don't want a union. And workers will agree. And I know many companies which are working like this. Now, tomorrow, some union will come and say, no, there's no union. We are the union. This is a sole bargaining agent. You have to give us the right to bargain. Gone. there was no question of even management saying that no, there is no question of union here. None of our workers want the union, but you will have a union, thrust on the management. And I think this is something which is absolutely absurd. Nobody has even thought about this process. So I do see that, it will impact the industrial relations in many organizations. Small and, medium organizations, will have increasing union activities, and a lot of disputes and issues can be raised, can go directly to the court. There is no need for, government to come into this picture. So many things will happen, which in my view will disturb the overall industrial relations environment. Today there's absolutely no much problems today. Business is not doing well. So union bargaining power is low. They are very reasonable. They don't want the units to close. They cooperate. So this is a very good tradition. In spite of the restrictive provision in the industrial dispute, this has happened. Now with the code, I do see that, it will again ruffle and it will take time to settle down. It will not happen overnight.
True, sir. True. I hope it's not from frying pan to fire. Anand, would like to add anything more, or can I move on to the next questions?
Yeah, you can go on to the next question.
Yeah. The next question is again from the Facebook viewer. Before that, I'll take that chat box question because they are sitting with us. He's not put his name. It's come from his Galaxy phone. What happens to the Supreme Court February 2018-19 decision, which has not been clarified for implementation and compliance under the new Act? Will the employee covered under the Provident Fund Act, can the transition out when they move to the new law?
Yeah. That is going to the Supreme Court judgment of 28 February 2019 gets watered down once the Social Security Code gets notified. Please note that none of the codes have been notified.
Sorry, Anand, you have to tell them what is the 2019 Act.
Yeah, I will.
Sorry.
Yeah. So first, the thing I wanted to point is none of the laws as on date have been notified. They come into force only on 1st of April 21 that's what has been indicated. We still don't know. So that's the first point I would like to make. The Supreme Court judgment did say that a contribution on Provident Fund needs to be paid on allowances. And therefore, what was being paid only on basic and DA, everybody started to pay on allowances excluding HRA. So the question that's being now put is what happens to this judgment? This judgment gets watered down now. It is sufficient compliance hereafter if you pay Provident Fund contribution on 50% of the gross wages. So if your gross wages is 20,000, now currently you may be paying on 15,000, but once the new code comes in, it is sufficient compliance if you pay on 10,000 rupees, which is 50%, or if your basic and DA is higher than the 50%, you need to pay on the basic and DA. So if 12,000 is your basic and DA, you may need to pay on 12,000. If it is lesser than 10,000, then on 10,000. So therefore, yes, this judgment is going to get watered down. Yeah, that's my reply to that.
Thank you, sir. Here's a question again from a Facebook viewer. Section 62 of the Industrial Relation Code says that 60 days notice period is mandatory for calling a strike. In another clause under the same section, it forbids strike within 14 days of issuing notice. What is the difference between the two, sir?
That's been there already. Even under the ID Act, you had a very similar provision. It is not something new that has come about only in the code. So I will put it this way: without a 14-day minimum notice, a workman or a union cannot go on strike. So the good thing about this code, IR code, is that any strike is going to become illegal strike.
Or lockout.
Or lockout as well, yes. So yeah, it's a challenge for both. Yeah, I'm thankful for pointing out that. So whether a management wants to do a lockout or a workman wants to go on a strike, both are going to become illegal. So the consequences, loss of wages and 8-day wage cuts and everything flows in. The question is 60 days that is being specified there. To be honest, it looks a gray area to me, but I would say that you need to go for a strike within 60 days of giving that notice. That's the way I think it can be read. There is some lack of clarity. Dr.
No, I think that's correct.
Have your thoughts?
The first clause of 60 days is a generic condition that if you threaten an agitation, it will take place within 60 days. If it takes place after 61 days, it will be illegal. So let's say I'm going to agitate on bonus. And I'm giving a strike notice. When I'm going to give a strike notice and say we're going to strike work, I don't tell the date on which I'm going to go on strike. This notice will be valid for 60 days. If I go on strike any time after the 60 days, it will be illegal. Then so before going on strike, I must give 14 days notice. This is what it means. This is so what it was. 6 weeks was there earlier. Now it has become 60 days.
60 days. So it becomes like you can go on strike between the 15th day and the 59th day or 60th day. So that's the period during which they can go on strike.
Correct.
Okay, well understood. Thank you, sir. There is a question again from the chat box from Mr. Vengat. What do you want? Is it not mandatory to follow the certified or model standing orders for working conditions, retrenchment or termination, etc.? In case of company employees less than 300 employees, the 300 limit includes contract labor employees or only the muster roll or on-roll employees. I think you clarified that during your speech. Yeah, maybe you like to add on.
Yeah, 300 is only workmen. Contract labor is not included. In fact, the definition of contract labor itself has undergone a radical change, I would say, in all the codes. I don't want to go into that aspect for now, but 300 is only your workmen. So if you have 300 plus workmen, then you need to have a certified standing orders. If not, you don't need to have a certified standing orders. Even if you have more than 300, only if you want changes to the model standing order alone, you need a certification. Otherwise, you can simply write to the government saying, I want to follow the model that is there and I don't want any change. So then you don't even need to get any certification done. That's the new provision that comes about. So yeah, the answer is two things. One, 300 is only limited to your workmen, and even above 300, there is no requirement for a certification process to go through.
A question from a student from College of Laws. It's a question addressed to Mr. Anand Gopalan. He wants to know the civil court jurisdiction in respect of any matter under the provisions of Industrial Relation Code 2020 is barred. How will this impact the industry in terms of dispute resolution and ease of doing business?
Again, this is not a new provision. Even under the ID Act, civil courts were barred. You can go only before the labor court or tribunal. Now they have removed even labor court. It's only tribunal is there. So it's not something new. It's actually a kind of eases. There is an ease of doing business in this because there is going to be a specialized tribunal which looks into it and not a generalized civil court which looks into all these disputes. So the specialized tribunal has knowledge on labor laws, or at least supposed to have knowledge on labor laws, and they will be looking into it. So when you look at ease of doing, it is certainly beneficial to go before a specialized tribunal to hear these matters than a civil court. So, and it's not a new provision. That's my answer.
The question from Mr. Gopinathan, what you know, recently he says there's a political leader who is demanding 80% quota for local residents in private sector jobs. What's your view on this, and how does the new act is going to deal with these issues?
I think Uma represents the private sector. We'll put her in a spot here.
Uma, what do you?
Really, you have. Yeah, well, see, it's always good to give employment to people who are around your factory largely. It's a good thing because you can do things for the community and they can actually, have a lot of allegiance and commitment towards the industry. So there's no doubt on that. Having said that, I think opportunity to earn livelihood is everybody's right across the country, and they could actually move anywhere they wish to get employment. We all know very well that within our country, not every state has got the same opportunity in terms of employment. And so if people do seek out, after all, they're Indians, and they can be in any part of the country and do what they have to do. Secondly, if they possess certain skills which are not available around, and it makes more sense to have people like that, certainly the industry would like to engage them. Let me tell you, people across the country have got very unique characteristics, and they actually bring a lot of strength because of the diversity that we have in our country. Certain parts of the country have people who have a characteristic which will be more suitable for the industry in which you are. And therefore, if you don't employ them and you're trying to do the whole skilling business, it's a long-term thing. So for you to get to that point will be very difficult, and which is why in India, migrant labor have been there. And they have been adding value to many, many industries because of what they bring to the table. So I believe that you must have a healthy mix and not sort of get concentrated with only one set of people, because it's diversity is always good for an organization. And so we should not rob organizations of that freedom to bring that diversity into the workplace. So that's my response.
I would just like to add here, that you should have people available in that local area. Skilled jobs, people are not available. So this 70% or 80% or whatever percentage you put, if that resource is available, then companies would definitely be thrilled to have that person. But when they are not available, what do? You can't allow a very costly equipment costing me crores of rupees to lie idle because I don't have the manpower for that. So very often the situation emerges that it's a reality that we don't have we have a lot of labor, but we don't have skilled personnel to manage the equipments that we have.
Yes, I think get them trained on technology oriented is the future.
The legal provision is that an Indian anywhere in India can seek employment elsewhere. And if he is denied employment on that ground, he can challenge it as a violation of his fundamental rights. Courts will, in the past, courts have ruled that this is illegal. So, it's likely that you will get judgments on the similar lines.
Another question from the YouTube. Yeah, you would like to add on, Uma? Please go ahead. Anything? Can I go move to the next question? Okay, thank you. The next question again from YouTube, Mr. Verma. What do you want to know? There is a thought among the IR experts that since the discretion of the government to decline the collective dispute has been taken away by the IR code, there is a likelihood that a large number of collective disputes on trivial demands which will be made by the trade unions. What will be the opinion of the panel on this? I think Mr. Krishnamurthy really brought it out. Maybe you would like to add that in your speech you brought out this issue. Anand?
It's an advocate's delight, lawyer's delight. That's all I can say there. We lawyers welcome it. Yes, it's not to the benefit of the industry. There is going to be it's opening up a Pandora's box, as we already discussed.
Good for business, for lawyers.
Okay. You already made it, sir. I think very good for Mr. Anand. I think happy days are ahead. Now we got a Kanaga Lakshmi. She's a question that she's come from chat box. I read the question also. In the new code, certifying surgeon is termed as a medical officer. Is it mandatory to qualify the certified surgeon course, or any medical practitioners can be appointed?
I think currently it's any medical practitioner, but again, we need to wait for the new rules. Mr. Ilangovan said he's drafting them. He's sitting in Delhi and drafting it.
Yes.
So we need to wait for those rules. So it's too early for us to comment on it, but it would be any qualified person in terms of the rules.
Okay, sir. The other question, he says the rule 3 of the code wages. I think the question is very interesting. I couldn't understand, but maybe you will be able to decode this. Rule 3 of the code wages 2019, which fixing the criteria for minimum wages, has taken into consideration such as intrinsic issues like calories, intake per day, and the number of meters of cloth required per year for each member of the family. While such an effort is highly appreciated, do you think the implementation of such rules is practical, given the fluctuation in the inflation rates, wide disparity in the standards of living and place to place, and etc.?
One, this has been the standard that has been followed for the last 50 years. So it's called the Accuride Formula, and that's the formula that has been followed, Dr. Accuride's formula, and now that is being giving a legislative flavor. So behind the scenes, the government has been using this formula to derive at minimum wages. So whatever minimum wages the government has till date notified, it has been only based on this formula of family consisting of 2 adults and 2 kids taking into 3 units, and then their food requirements and all these requirements as proposed by Dr. Accuride. And that formula is now being made into a legislative intent is being given to it. So it's not new. It has been working all these years, and I think it will continue to work as well. So it gives it a more statutory flavor for the formula, nothing more than that.
Super, sir. Another question again from the social media. The near total absence of any social security, especially for the unorganized migrant workers, came to the fore most painfully during the lockdown. The long walk home of the thousands of destitute migrants, the death and the distress of shocked many. Keeping that in mind, do you think the proposed legislation will guarantee the basic fundamental rights of life and dignity to our laborers?
I think Uma and Dr. Krishnamurthy, they can share on that.
What
I think the first thing that we need to understand is that the amount of migrant labor employed in some of the cities like Bengaluru, Chennai, Mumbai, it was an eye-opener. It was really a shocking eye-opener because nobody ever realized that these cities have become so dependent on such guys who are coming from long and very far off places and have contributed to the economy of the place. So to a very great extent, the code recognizes that migrant workers have a role, and though it was marginal, they have now tried to incorporate some provisions to cater to this group, that free toll number, portability of rations, and many other things, that give them some more rights, which have been now codified. But as far as their jobs are concerned, they are always very mobile. I mean, many companies never recognize them as migrant labor, but they have been in the city. They are not people who have got domicile certificates in the state. They may be in Kerala. I've seen people from Assam going to Kerala and working in Kerala. But they will always remain as migrant workers only. Many of them settle down in Kerala only. They will not go back to their native place. Once in a while, they will go. But actually, for all practical purposes, they are all employees of the state. They have not completed 15 years. But for all practical purposes, they have become members of that state itself. So this code does not solve the problem of migrant workers. Migrant workers will, if places like Bihar, Odisha and all that don't have jobs for their population, they will have to look at places elsewhere. See, this migrant workers, actually, the theory was slightly different. These people have not understood that problem. Earlier, contractors used to go to villages and pay 30,000 rupees, 40,000 rupees for any person who was capable and fit. And they will take them, as labor, unskilled labor. And he will bring, in fact, even today in Tripur, people get 2,000 people from Bihar, 2,000 people from Odisha, 2,000 people from West Bengal, and he will house them in his own quarters. He will have a cook who will look after their meal one time in the night. He will arrange for their entertainment on Sundays, taking them out for movies and also out for shopping. And this is the way in which it has been dealt with. This has not been addressed at all. So to a very great extent, the system will prevail. The contract labor will pay the money there, and then they will not pay the wages fully, because they are already paid. So this is the system, and the Act in no way interferes with this system which is going on, and it will continue.
It's the mindset of employees will have to change. Maybe Uma would like to add.
I agree with Dr. Krishnamurthy because employers who have taken care of their different categories of employees will continue to do so. I don't think there's going to be a big change in that. But certainly, I welcome the fact that they will be registered, they get a passage home, etc. This will be an outflow for a company, but I think it's well worth its time that they should do it and budget for it. And also the free ration, etc., which is important. They're also talking about housing for them, which I think is a very important thing if people are going to do it. But when I was going through this, I'm thinking practically, how does an industry rise to this? Actually, how are you going to do this? Because you're not even building houses for your own employees anymore, right? Because of the CTC concept. So who's going to actually do this? So if at all this is going to be mandated, there has to be a consortium of industries which has to think together in a region as to how they're going to arrange for these kind of things, rather than every company trying to battle it. So I think that it's not very clear, but I welcome whatever little is being done. I think it's important.
Yeah, I checked with some of the textile industry. It's a contractor who does the entire, arrangement of, stay and all that. And it's amazing, he has got number of beds in a room, as many as 10 or 12 people will be crammed.
Yes.
And he will arrange for their lunch, he will arrange for their entertainment. But it is a really tough life, and they'll work, for that period for, 12 hours and all that, earn overtime. And then 1 month they will go back to their native places, which he will finance. Which was being done by the contractor only. It was not being done by the principal employer.
That's, I think another 6-7 minutes are there. I'll try and squeeze in as many questions as possible. Number of questions are with me. And here the one comes from the chat box is from Venkat and also from Mr. Ganeshan, he's our Untitled Chapter chairman. What is the status of bonus with the new code and the earlier Supreme Court case on bonus? And Mr. Ganeshan want to know what is the legal backing for VRs? I don't know, maybe voluntary services. Maybe you would like to quickly attend, then I can go for some interesting questions. Over to you, Mr. Anand. You have to unmute yourself.
Sorry. I'm sorry. The bonus, the calculation of bonus is going to remain the same as currently, whatever it is. So it is going to be linked to minimum wages. The case before the Supreme Court in 2015, which was filed of linking bonus calculation to minimum wages, is pending. But once this code comes into force, the life of that litigation may get shortened. In the sense, what I mean is, it's going to be effective. Whatever judgment that comes is going to be effective only from 14 to March 21. So from April 21, it's going to be the new code which is going to take over. So, and if again it needs to be challenged, it needs to be challenged again, the bonus provision.
Here's the question again from Twitter. I asked this as Indian labor laws have been mostly politically stubborn area to reform, standing in the way of China-style industrial acceleration. And what's your comment? Is also Mr. Grover want to know that do you think this new act will boost employee welfare, and are employer friendly?
Well, I simply put it as once in a decade. I mean, once in a century. It's like the pandemic. So 1920 we had a pandemic, and now again once in 100 years we have these new laws coming in. Impact we need to see. I think Uma wanted to share something there.
No, yeah, I mean, I think, it's not either or. It's not like employee welfare versus employer friendly. It's not like that. I think it's got elements of both to it, as we can see clearly. As Mr. Anand said, we have to see the fine print into this and the rules, etc. But on the face of it, certainly it appears that both elements are there. And also the ease of business definitely is kept in mind while doing this. Whether we get a China style, ready situation for somebody to start an industry or not, I don't know, because it is a fact, because in one of the companies that I work, a FMCG company, we tried to set up a chocolate factory for about, I think, 4 years. And it just didn't work out because of the number of hassles that there were in doing it. Now, this will surely and absolutely clearly set people away from us. So there has to be some reasonable way of doing business. And I think if that is promoted to become and if you call it employer friendly, I think it is great, because it will boost employment for us and also bring more revenue into the economy, which I think we very badly need out here. So I would say that it's not an either or, it's got both.
Here's the question that I say is again from social media. India is projected to have the largest working population in the world shortly. But do you believe that we follow the labor laws strictly? How can we focus more on application of the labor laws more? How do you make the industry adapt to the labor laws, implement them with the spirit of implementation? And they also want to know that now the government itself is encouraging work from home to be the concept implemented across various sectors. What are the practical difficulties do you see in being applied practically in terms of its impact on this labor laws?
I think again, Uma would be the better person to answer on work from home and industry. As well as
yeah, I'll give it a shot. I think work from home in a manufacturing company will always be limited. Because people, if you look at any organization's makeup, you probably have about 40% of your workforce which are in the factories. And then you would have some 30 or 40% who are out there selling your product. And then you have the rest of the people. If that be the composition, then, this work from home is always going to be limited. And it's going to be limited to probably a 30 or a 40% of the population. Certainly, we can't think of a work from home for a factory employee. Whether a workman or this, I wish it was true that they could do something on the computer and then things just get produced and trucks go over there. Having said that, let me tell you, we have launched our products virtually. In this lockdown, we have launched 2 products virtually, which we never imagined that we could do. It was always a large expo having thousands of people, etc. Certain things can happen, but at the end of the day, the person who's selling, is producing a physical good, and the person who's selling is selling a physical good. So this work from home, as recently government has announced, is more for the technology aspect of it. And again, let me tell you one thing, it's not that simple. If an organization decides to go for it, there will always be comparison that others will make. Somebody gets it and I don't get it. So what am I going to get in lieu of that? So is it really worth doing something which is going to create such a disparity and put things out of gear, is a question that many employers may want to ask. So therefore, it's not an absolute work from home, and industries like ours will never go for an absolute work from home. They will go for a blended model. And that means you have to change a lot of your policies. You'll have to change a lot of your processes to make it happen. And it's not just for women, I'm saying it could be for men as well. But we have to be carefully thinking about which areas can convert into work from home for us. And there has to be an economic benefit and a social benefit of doing it. Otherwise, it's pretty meaningless to pick up all these things and run with it.
Now we'll come to the almost end. I'll take, with the permission of the chair, one last question. This is from me actually to all the panelists. You could ask them. What I want: if there are 2 changes that you are asked to propose now, what will be your take on this and why? The new act which has come. If you're asked to bring 2 changes which is mandatory to be brought into the new act, and why it should be there and why? Each one of you.
Can I start?
Yes, please.
Okay. So one is, I think, flexibility. As the Hollywood movie says, come with freedom comes a lot of responsibility. So it's nice to have rules which are flexible. But I think what I would like to see is how are we going to review this, monitor this, and ensure that they're done in the spirit of the law and not otherwise, and not exploitative. So this is one thing that I would like to see. Number 2 is, as I said earlier, very heartening that women can be employed everywhere. Are we ready with the conditions for women to work in various places? When I say conditions, the ergonomics of the factories, equipment that they use, the commute, the safety, the conditions of relaxation and periodic intervals for pregnant women, etc. All these things have to be well thought out. And I think I really want to see whether that is going to come by. And that's when really more women will actually get into the workforce.
Dr. Krishnamurthy, your views on?
Yeah, I think instead of telling you 2, I will tell you 1. We are having more of laws. When we say code of industrial relations and code of wages, we have actually got 4 codes now. We should have had only 1 code. Okay, and that's the way to do business. Very simple way of doing business. And not, this is actually, you've got all these 29 acts now. They are all sitting in one building. Earlier you had different buildings, so this each and every law. Okay, now they are all housed in the same premises. But the fundamental change has not taken place. So I think basically, if you are to ask me, I would just disregard the laws, keep some of those things, particularly relating to welfare and health and safety, very stringent, and permit a lot of freedom to engage the type of people you want and the type of rules and regulations you have to frame yourself. Don't come to the government. And government will come down very heavily if there's a breach of law by either of the parties. So workers resorting to violence, workers resorting to, go slow and other activities, you have to penalize them. Similarly, employers not doing the business the way they should run and, actually persecuting the employees and creating problems. You invoke your penal provisions, make them realize that these are not acceptable way of doing business. And today, if you see, many of the companies are really, compliant in terms of the compliances. They pay quite a lot of attention to the compliances. So that's what I would like to do. One thing that I would like to do is make the laws a little more simple and more relationship oriented rather than litigation oriented. And I think today the law is heavily litigation oriented. For everything you have to go to a lawyer and only the lawyer will guide you. That should not be the case. You should have a situation where you should be able to resolve the issues and problems, not go to courts. You must compel people to resolve the issues across the board. Otherwise, appoint arbitrators and they will decide the matter within 1 month. You can't just keep it hanging like this. for so many years, 6, 7 years, the matters go on the labor court. Is this the way to handle things? No. 1 month it should be decided. You are right or he is right. And don't go into what the conditions of service should be. That they should work out and interpret. Only arbitrator will interpret the law. He will not decide the law. You and the employee decide the law. That's how it should be. And government will regulate minimum wages, minimum hours of working. And the role of government is purely regulatory. That's how it should be. It is not like that.
Excellent insight, sir. We'll share this entire recording to a couple of people in the ministry. And in fact, Mr. Ilongon is very keen to have the entire recording. In fact, we'll be sharing with them as soon as possible. What to you, Mr. Anand?
Yeah, my take would be, to a large extent, they have reduced the penal provisions and they permitted compounding of offences. So if there's a non-compliance and if it is pointed out, you can just go to the authority, pay a fine and be done with it. That's been brought to a large extent. I would have been glad if that was the only course and the prosecution aspect, as Mr. Krishnamurthy was saying earlier, is taken out, because this doesn't have any intentional mens rea, as we call it legally, for which they have done it. So except for maybe where it is a fatal accident, in all other cases, they should have been done away with prosecution in all acts. At least, even if the Factories Act alone is left out, other acts, they should have taken out the prosecution. That would have been a more employer-friendly or ease of doing business coming in, and clarity and fear of what is going to happen. That would have been something. And on a general perspective, I think there has been a lack of application of mind. I'm sorry to say that, but there seems to be a lot of loose ends that are to now be tied up. There are going to be amendments to these codes, is my personal feeling, or it has to happen. Otherwise, there's going to be a lot of places where it's going to be ambiguous. So they would need to bring in. So there's a general drafting has been not up to the standards. These are the two things I have a grievance against these codes.
Thank you. Thank you so much, sir. We have come to the end as we proposed 7:40. I think we should do that because we firmly believe that we must do it on time. And thank you so much. Great insight shared by you. And I can assure you that we'll soon, as soon as the rules are formed, we'll have a one-day conclave bringing in the officials from the Ministry of Labor, so that the authors should also be with us to defend themselves. Why did we do that? And we have some experts like Dr. Krishnamurthy, Anand, and Uma. It's a great, it's indeed a privilege to have you with us, sharing your insight on some topic which 1 hour 40 minutes is just not sufficient. We need almost quite a bit of discussion. We will be doing more such discussions in future. And thanks so much. Thank you, Anand, for ably really facilitating and also ably leading and bringing the best out of the distinguished panelists. Thank you, Dr. Krishnamurthy, for joining us in spite of a busy commute from Mumbai. And your insights are really, really very valuable. And we'll keep in touch with you to bring more such insight for a lot of people, a lot of questions which has come. And as usual, thanks so much. Brilliant insight from the industry perspective. Thanks. And as a token of our appreciation, that's what we do in MMA during the pandemic time. On behalf of you, we would like to present 300 face masks. We'll go around, my team will go. Thank you, and we really appreciate your thing. What we do, our team goes to different places, we educate them, make them wear the face mask, different places. I thought this will be a good initiative, what we should be doing that. Thanks so much. Thanks to all the viewers watching this program live from different social media, and also people who are joined on live on radio. And this recording of this is available to us, our website, and we also share with you. And the article with the embedded video also will be out very soon. Thanks so much, and it's indeed a great pleasure and privilege to have you this evening. Thanks for again, distinguished panelists. Stay safe, stay healthy. Till we meet again. Bye-bye. Good night. I'm quite sure the people who attended the takeaway, they would have become more wiser and more wisdom, and are more confused to ask you more questions future. That's not our job. And thanks so much. Bye-bye. Till we meet again. Good night.
Thank you, Group Captain. Thank you.
Thank you very much.
Thank you, Dr. Krishnamurthy. Thank you. Bye-bye.